Welcome to this episode of Term Talk, a video podcast that explores recent developments and trends in Supreme Court jurisprudence that's important to the lower courts. I'm Jim Chance, Senior Judicial Education Attorney at the Federal Judicial Center in Washington. In this episode, we discuss developments in the jurisprudence of universal injunctions. This term, in a 6-3 decision in Trump versus CASA, the court opined that lower court imposition of universal injunctions likely exceeded their equitable authority, and they vacated the injunctions, 3 injunctions, without deciding the underlying merits of the case. I am so pleased to welcome in person Erwin Chemerinsky, Dean and Jesse H. Choper Distinguished Professor of Law at the University of California, Berkeley Law School, and Tara Grove, Professor and Vinson and Elkins Chair in Law at the University of Texas at Austin Law School. It's so wonderful to be able to have this discussion with both of you in person. Tara, can you define universal injunctions, also called nationwide injunctions, and tell us a little something about how their history and how they might differ from other actions the lower courts might take in a case?
What's called a universal injunction, sometimes a nationwide injunction, just means that the court is stopping the government from enforcing a particular government action against anyone, not just people who happen to be named parties in the case. And this issue came up in the birthright citizenship litigation because courts issued this kind of injunction in that litigation. So let me just give a little bit of background. The 14th Amendment of the United States Constitution says that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, end quote. Seems pretty straightforward. If you're born in the United States, you are a citizen. On January 20th, 2025, President Trump issued an executive order that said, even if you are born in the United States, you are not subject to the jurisdiction of the United States and thus not automatically a citizen if your biological mother was undocumented or here just on a temporary visa and your biological father was also either undocumented or here on a temporary visa. Those individuals, the executive order said, are not citizens. As you pointed out, this went to 3 different federal district courts that all held the executive order was likely invalid, likely in violation of the 14th Amendment, and enjoined it nationwide in what is called a universal injunction.
And Erwin, why did the Supreme Court choose to decide only the issue of the injunction, and why now?
All the United States government asked the Supreme Court to take up was whether or not the nationwide injunctions were permissible. In fact, the petition for review by the Solicitor General's office, the Supreme Court said, we're making, quote, a modest request, just rule on the constitutionality and the legality of nationwide injunctions. And this is not a surprise that the Supreme Court was going to be inclined to take up the issue at some point. Several of the justices previously had indicated a desire to take up the issue. And there's certainly a split of opinion among scholars and others as to whether nationwide injunctions are desirable or not. On the one side, you find the critics of universal injunctions say it leads to forum shopping. It means that the government has to win every place. If they lose in even one court, there can be a nationwide injunction. They said that this is unprecedented in terms of the tremendous growth in nationwide injunctions. But on the other side, there are those who say, if there's not nationwide injunctions, does that mean the plaintiffs have to file separate suits in all 94 federal districts? Does that mean there could be a patchwork where a baby born in one district be a citizen, but a baby born in identical circumstances in another district wouldn't be a citizen? Does that mean that even if several courts rule the presidential action unconstitutional, that the president could keep doing it everywhere else until the resolution by the Supreme Court? So given this debate, it wasn't a surprise that at some point the Supreme Court is going to take up this issue with regard to the permissibility of nationwide injunctions.
How did they analyze the legality of nationwide injunctions?
So the court focused just on whether the lower courts had the statutory authority to issue nationwide injunctions or universal injunctions. The court found the only possible source of authority would be the equitable authority that comes from the Judiciary Act of 1789. This is a statute that created the federal courts, did give the courts jurisdiction over cases involving equitable issues, and the court said that had to be the authority. Justice Barrett's opinion also said that the only way universal injunctions could be authorized is if they were somehow similar to equitable authority that courts had had in 1789 or around that time. And the court found that there really wasn't any similar analog to universal injunction at that time. The court talked about a practice that did exist in early British courts called the Bill of Peace, and said, well, the Bill of Peace is not that similar to the universal injunctions that we have today. Courts, when they were dealing with the Bill of Peace, were dealing with a smaller number of plaintiffs. The action would bind all the parties to the suit and actually was much more similar to what we have now as a class action under Federal Rule of Civil Procedure 23. So the court said there was no historical analog, so you can't have a universal injunction under that statute. The court did say, though, lower courts can still issue potentially quite broad relief. The court said that courts have to have the power to give complete relief to the parties, and sometimes that extends beyond people that are actually involved in a case. So the court briefly mentioned in a footnote reapportionment cases, and this is a pretty straightforward example of this. If plaintiffs challenge the makeup of a particular district in the state, and they say that it's perhaps racially gerrymandered, so it has to be redrawn. Well, if you redraw a district, that's going to affect all of the voters in that district and potentially all of the voters in the state, because it may require the redrawing of every single district in that state. So sometimes complete relief actually does mean pretty broad relief, even if not universal relief. And that leads me to a couple of other important things about the case, and that's what the court did not decide. So the Supreme Court was asked to decide whether universal injunctions were consistent with the United States Constitution, and specifically with Article 3 of the U.S. Constitution, which says that federal courts can decide cases or controversies. But the Supreme Court did not decide that question. So as a constitutional matter, universal injunctions, at least so far, may still be completely fine. The Supreme Court also did not decide how much relief people can get when they bring actions against administrative agencies under the Administrative Procedure Act. That statute allows federal courts to vacate agency regulations, and that would seem to allow federal courts to do a lot of stuff that looks pretty broad, maybe even universal, but the court didn't rule on that. The court also did not rule on the scope of state standing, that is, states' power to bring suit, particularly on behalf of private parties. And that was important in this case because some of the plaintiffs in the birthright citizenship litigation are states. And one of the questions is, can states sue to protect their residents' 14th Amendment rights? We don't know the answer to that, but the Supreme Court did indicate in Trump v. CASA that complete relief to states might be quite broader than complete relief to private parties. And finally, the court left open the possibility of class actions, but did not actually rule on the scope of class action relief in this case or other contexts.
So, Erwin, Justice Sotomayor wrote a dissent joined by Justices Kagan and Jackson, and a separate dissent by Justice Jackson. How did they disagree with the majority? Walk us through that.
These are as vehement dissents as you'll find anywhere in the United States reports. They disagreed with everything in Justice Barrett's majority opinion. First, they disagreed with regard to methodology. Justice Barrett said that the answer as to whether there be nationwide injunctions is found with whether the High Court of Chancery could issue them in England before the Constitution was written, before the Judiciary Act of 1789. Justice Jackson, in dissent, says, in England, no court could stop what the king was doing. Why are we looking to the High Court of Chancery as whether federal courts can stop what the president is doing? Both Justices Sotomayor and Jackson argued that the nature of equity is inherently flexible, and courts should be able to do what's necessary to give complete relief to the parties. Second, the dissent disagreed about history. Justice Barrett said there was nothing historically like a nationwide injunction. Justice Sotomayor said the Bill of Peace was like the nationwide injunction. Justice Barrett says nationwide injunctions were unheard of until a D.C. Circuit opinion in 1963. Justice Sotomayor says there have been nationwide injunctions going back at least a century, and she gave examples throughout the 20th century of them. And perhaps most important, the dissent disagreed with regard to whether it's appropriate to look at the consequences of eliminating nationwide injunctions. Justice Barrett was clear. She said since there was no authority in the High Court of Chancery in the 18th century, federal courts lacked this power. Both Justices Sotomayor and Jackson wanted to talk very much about the consequences of eliminating nationwide injunctions. For them, they see a president who's repeatedly challenging constitutional bounds, and they see a Supreme Court weakening the ability of the courts to check that president.
Tara, how will this opinion affect the lower courts?
So a lot of action is going to happen going forward as people try to deal with the questions that the Supreme Court did not decide in that case. So first, plaintiffs are going to bring a lot more actions as class actions. This has already happened in the birthright citizenship litigation. Those cases are now pending, and we'll see what happens going forward. I think in many other contexts, plaintiffs will also try bringing class actions. Plaintiffs are also going to try to figure out what is the scope of complete relief. So in a concurring opinion, Justice Thomas expressed some concern about this language in the Supreme Court's majority opinion. And he said, complete relief could be something really similar to a universal injunction, which we've said is not okay under the Judiciary Act of 1789, and Justice Thomas has broader constitutional concerns with him as well, I gather. And so he said, plaintiffs should not be able, through this guise of complete relief, to be able to get something approaching a universal injunction. But in some contexts, plaintiffs will argue that complete relief does mean universal relief. I gave the example of reapportionment earlier. We go back further in history to desegregation cases. When a district court ordered a school district to be desegregated, that would involve far more than the parties to the case. Everyone potentially affected by the school district, and sometimes even surrounding school districts, at least up to a time. And so in some contexts, immigration contexts and others, plaintiffs are going to be arguing about the scope of complete relief. There are also going to be huge questions about the Administrative Procedure Act. So the Supreme Court left this open. And because of some other recent decisions by the United States Supreme Court that make it easier for people to bring suit against the administrative state and to win against the administrative state, there were already going to be a lot of actions under the Administrative Procedure Act against federal agencies. And this decision makes that a very valuable tool to get potentially very broad relief. When a federal district court vacates a rule or regulation issued by a federal agency, does that only apply to the parties, or does it apply to the entire rule against anyone? If it does actually vacate the rule, that would seem to be very much akin to a universal injunction. I also expect a lot of action in the world of lawsuits by states. We've already seen a huge rise in the number of lawsuits by states since around 2007 and going forward. State attorneys general are suing about pretty much everything the executive branch does, regardless of who occupies the executive branch at a particular time. And the Supreme Court's opinion in Trump versus CASA makes the scope of state standing all the more important because the court strongly indicated that states could get much broader relief. So these are all things that are going to be brought to the lower federal courts. I do want to say, though, it is quite possible that the Supreme Court's decision in Trump versus CASA will, in a sense, make life a little bit easier for lower federal courts. Because over the past couple of administrations, what we have seen is plaintiffs challenging the executive branch action, whether it's a Republican president or a Democratic president, different plaintiffs, but still bringing these challenges, and asking federal courts to rule on issues of extraordinary importance in a matter of days and issue universal injunctions against those orders. That is a tremendous amount of pressure to put on lower federal courts, and I think it's at least possible that this decision will reduce that pressure, at least to some degree, and make it easier for lower federal courts to, at a minimum, take more time before they're ruling on issues of magnitude.
Thoughts about that, Erwin?
On this, I think I disagree with Tara. I think that it's the issues that create the pressure for the lower federal courts, not the request for a nationwide injunction. When there's an unconstitutional, allegedly unconstitutional, executive policy or congressional statute, and people are being hurt by it, they're going to want the federal courts to rule quickly, even if the federal courts can't issue a nationwide injunction. Also, I think this is going to put real burden on the lower federal courts to have to decide, are there alternatives and are they permissible? Can there be nationwide class actions? Just the process of certifying a nationwide class action is additional burdens on the lower court. When can states sue on behalf of their citizens? They're hard questions with regard to third-party standing. What's the effect of the Administrative Procedures Act? Can something be vacated? All of these are questions that are going to be litigated in the lower courts, and without nationwide injunctions, they're going to be litigated all over at the same time. And that's, I think, the landscape until we get more clarification from the Supreme Court.
All right, thank you both for being with us today. It's been a pleasure to have you with us.